In the previous few lessons, what we've been doing is talking about the methods of constitution of a trust. We focused on the idea of the transfer of legal title in the previous lesson. In this lesson, we'll talk about the second major element of, or at least method of constitution, which is, of course, the self-declaration. Now, as I've just mentioned, as I've just said, the transfer of legal title is one of the ways in which we can achieve the creation of a trust, the perfecting of constitution of a trust. This lesson is going to examine the second major method by which a trust can be established, this being through the self-declaration by the trustee themselves. Now, as a general recap, we remember that when we create a trust, we are talking about the settlor or the testator, depending on if they're alive or dead. We are talking about a trustee, and we're talking about a beneficiary. When we are in the process of creating the express trust, the settlor or the testator is tasked with the job of transferring legal title to the trustee for that trustee to then hold that property on trust for the benefit of the beneficiary. Okay, this involves the division of legal and equitable title because then the beneficiary has equitable interest in that property, owing to the fiduciary relationship that exists between the trustee and the beneficiary. In addition to this, therefore, the idea of constitution is a question of the process by which the settlor or the testator transfers the property to the trustee. We looked at this in the previous lesson by way of simple conveyance of property, i.e. a trustee is given the property and it is transferred whichever method, depending on the property that we're talking about. So if it's land, there's basic rules for conveyancing. If it's securities, there's rules within Section 770 of the Companies Act. If it is chattel, then we have to think about the process by which personal property is transferred. Those are all the methods by which we see the ordinary transfer of property. This second method is known as self-declaration. Now, the concept of perfecting a constitution by way of self-declaration is one that is incredibly rare in today's modern context. There are two reasons why this is the case. Because the first of which is because it involves the owner of the legal title, the original owner, okay, declaring themselves to be the settlor and holding a property on trust, which means that essentially it can only be constituted with a settlor who is alive. So you can't have a testator doing this because testators are dead, and so as a result of which they can't declare themselves the settlor and hold property on trust because they're not alive. Okay, they can't, as far as I'm aware, dead people can't declare anything. Secondly, it involves the settlor declaring themselves to be the trustee of some property, and so there is not this need to transfer legal title because the settlor also becomes the trustee. This is sometimes something that can happen. So ordinarily, when we think about and how we've been talking about trusts, we've been talking about them in the context of having at least three individual actors involved, having a settlor or a testator, having a trustee, and then having a beneficiary. And we've been speaking about this in the context of the settlor being different to the trustee, them being different people. When we talk about self-declaration, however, the settlor is the original owner of the property, can declare themselves to be a trustee, and therefore they represent a settlor and a trustee themselves. So an individual can just unilaterally declare that they're going to hold property on trust for another person, this beneficiary. So there's only two people in this relationship. And so when we do this, there is no need to transfer title because you already own the title as the settlor and also as the trustee, so you don't need to transfer title to yourself because you already own the title. So instead, we rely on a process of self-declaration. So because this isn't a process which involves the conveyance of legal title, the idea of perfecting the constitution in these cases is easier because the settlor can declare themselves a trustee of the property, and they can do so through the use of language, or even through the implication of their conduct. The only exception to this particular set of circumstances will be in the context of land, given that according to Section 52 1b of the 1925 Law of Property Act, there will actually have to be evidence of the trust in writing, which is signed by the settler. So a settler can't just self-declare using language or implied through conduct the creation of a trust of land. They would have to do so by writing, evidence in writing of the trust itself, and that's the only difference. But they can still self-declare it, it just has to be done in writing. In 1977, we have an interesting case which illustrates all of this quite nicely, the case of Paul and Constance. In this case, you have a man who had separated from his wife, and then this individual then went on to live with another woman. The wife in this case was the defendant, and the other woman was the claimant. So you have a man who is, the man is just a third party, essentially, who seems to cause some of the problems. But the other woman is the claimant, and the wife is the defendant. The man had a bank account whereby he would deposit some of the winnings from a successful bingo trip, with the expressed view that this would be he and this other woman were able to withdraw funds from it. So it was going to be their money, okay, their winnings. In fact, it was even cited that he went on to go and say that the money was, quote, as much yours as mine, to the claimant, to this other woman. When the man died, it was argued by his ex-wife, the defendant, that the money in the account should pass to her through intestacy, okay, through the basic process of succession, essentially, of because the man died intestate, by the way. And so the question was, whose money was it, and how can we understand the creation of whether or not a trust was created here? It was held by the Court of Appeal that, in fact, a trust had been created by the man for his partner. And this is evidenced by the fact that his words and actions had implied the existence of the trust. And this was the case despite not using the word trust. And because he had created the trust himself, and the trust was, the property was held by him on trust, he had done so through self-declaration. He had created a trust as a settler and also became the trustee of that property. And so the words and the language and the implications of his language was enough to satisfy the requirement that this is the creation of a trust. Now, of course, if this wasn't the winnings from a bingo trip and it was instead land, there would have to be a requirement of that property being put on trust in writing. Still self-declared, but put on trust in writing. So what the case of Paul and Constance highlights is the view that was expressed in the previous case that we looked at, which was the case of Richards and Delbridge. The idea that the settler need not use the words, I declare myself a trustee. Instead, this would actually be a very limited view of the idea of self-declaration of a trust. Instead, you can use language to infer the existence of self-declaration. And so the case of Richards and Delbridge makes it clear that even if the supposed or alleged settler didn't use the words, I declare myself a trustee, if they use words that imply the existence of a trust, like was in the case of Paul and Constance, this suggests that they have self-declared the creation of a trust, and in so doing have perfected the constitution of said trust.